from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Our subject today is student press law. We want to particularly delve into high school newspapers, journalism, and how that may be the same or different from what we call the everyday journalism that takes place in reading your papers from the cities in which you live. In order to accomplish this goal, we are very fortunate to have a highly qualified individual visiting us from Portland, Oregon. Our guest is Mr. Mark Abrams, who is a noted attorney in the area of First Amendment rights questions, and particularly, as I've indicated, student journalism. He has authored 2 Supreme Court briefs concerning student rights, and he also has co-authored in the mid-1980s a book entitled Law of the Student Press. Our guest is the former director of the Student Press Law Center in Washington, D.C. He presently serves in a most interesting capacity. Along with his law practice, he is a member of the Portland School Board. Previously, he's had a lot of cases directed at school boards. Now he serves in a policy capacity. Also, our guest is a graduate of Wesleyan University in Connecticut, and he holds a master's in law degree both from the University of Michigan. Mr. Abrams, it's a pleasure having you here, and we thank you for the generosity of your time as we discuss what we believe is a very important issue to our audience.
Well, thank you for having me here. I'm glad to be able to be in Coeur d'Alene today and speaking to all your viewers around your broader area.
And I should add that the one reason why we've been able to have our guest today is that the North Idaho chapter of the Idaho Press Club and the Journalism Department of North Idaho College have been putting on this conference or workshops that Mr. Abrams has attended today. As always, I'm pleased to have our 2 regular panelists. First of all, Janelle Burke, who's an attorney in the state of Idaho, and next to her is Steve Schenck, who is the Dean of College Relations and Development at North Idaho College, and Janelle shall commence today's questioning.
Mr. Abrams, in order to lay the groundwork, let's talk about some of the distinctions between journalism for students and journalism, the regular kind of journalism that we read about in our newspapers every day. What are some of the basic distinctions that the courts make when they're dealing with these 2 different areas?
Well, the courts have always been troubled grappling with the idea of who is the government when you're talking about a student newspaper. The First Amendment in the private sector, when you're dealing with the Lewiston Tribune, the Portland Oregonian, the New York Times, recognizes that freedom of the press is freedom from government intervention, freedom from the federal government, the state government, the local government. That's a much trickier line to draw with a student newspaper, where the student newspaper may be in fact funded by and operating out of a school, and a school is your government. That's been the problem. For many years, the Supreme Court and all the federal courts beneath it very clearly said the government is still the censor. The students, even if they are being funded by the government, have a freedom from that government. 7 years ago, they swung around, at least as far as high school papers are concerned, in a case called Hazelwood School District versus Kohlmeyer, and said, you've got to first decide whether, for a high school paper, that paper is or isn't a public forum. And if it's a public forum, it still enjoys a certain amount of the freedoms that college papers and professional papers do. If it is not a public forum, then censorship is generally permitted. And so the test is now shifted not to what censorship is allowable and what isn't, to whether or not this is a censorable entity.
Okay, and let's talk now about some of the kinds of things distinctions that might be made between the kinds of things that students would be saying in a student newspaper.
Well, students should run their newspaper the same way they run a professional paper in the so-called real world. I don't like to think that there's any difference in ethics or any difference in goals. As I was telling some of the students at this workshop today, their job is to cover the issues that are important to their community that will not be covered otherwise. If you are a student newspaper, what can you deal with that the paper in Coeur d'Alene won't deal with, or won't deal with frequently enough for your ever-changing constituency that turns over every 3 or 4 years? Teenage alcoholism, teenage drug use, coping with parental divorce, a whole raft of very sensitive subjects that frankly principals and school boards aren't always comfortable hearing discussed in this forum, but which are very appropriate, and if handled responsibly by student journalism, and student journalists will be giving their readers information they can't get anywhere else.
How much does the fact that they're minors come into play, as opposed to adults?
Well, the issue is, at what point do we start giving responsibility in our society? We allow people to have driver's permits at 15 or 16. We allow them to drive that car at 18. I don't think that people wake up on their 18th birthday imbued suddenly and instantly with knowledge. Suddenly they're old enough to vote, they're old enough to marry, they're old enough to get drafted, go fight in a war and maybe be killed, whereas the day before they were too stupid to tie their own shoelaces. That's simply not the way people mature, and it's not the way the educational process should deal with them. Student journalists don't become editors overnight. They spend several years working up the corporate ladder of their student newspaper. Hopefully, if our schools have done a good job, if our school districts are competent, those students, by the time they are entrusted with the power of editorial judgment, will have developed the wisdom to use it.
Steve Sheik.
Mark, let me get a little more focused, and I hope this will help our audience grapple with some of these issues more clearly. What kinds of things, more specifically, aren't permissible? In other words, at what level, in your experience, can the government, in this case the school board, step in and say, nope, I'm not going to let you print that?
Okay, even in a public forum, the Supreme Court has long recognized 3 areas that are appropriate for some kind of, if not censorship, prior review, some institution of adult, if you will, authority. They are speech that is libelous, and that is defined exactly the same for students as it would be for the Washington Post. Speech that is obscene, and while the test is essentially the same as it is for the adult world, the test for obscenity does look at the sensitivity of the audience, and a younger audience is going to be more sensitive. But it still talks about dealing primarily with the prurient interest. So the Venus de Milo would not be obscene even on the high school level. The final area where some kind of supervision and perhaps control is appropriate is what's called speech that threatens with a probability of success imminently to disrupt the educational process. And unfortunately, that mouthful cannot be reduced to a shorthand without losing one or more of its critical elements. It is not speech that is merely unpleasant. It is not speech that is merely distasteful. It is speech that is, in essence, advocacy of disruption on a fast time scale and with a probability of success. Anything less than that, and our courts have said that really what you have to look to is not whether the speaker's behavior is inappropriate, but whether the actor receiving the speech is behaving inappropriately. So if I have a student newspaper or an adult newspaper and make a claim that someone is a Nazi, and that may or may not be libelous, but it's not inciting speech. If the gentleman comes and hits me on the jaw, his is the act society should regulate under the disruption standard, particularly if he is a Nazi and he can't sue me for libel, if I'm merely exposing him.
The whole question of libel, I think, is kind of interesting. And you, of course, in a school setting, you'd hope it never really comes up. But I'm curious, who sues whom in a case where libel takes place? The school board and school administrators are the ultimate authority. Students, I'm sure, in the eyes of the court would have some protection because, despite the argument that we've made earlier, they're not as capable as professional journalists yet. Is the school board responsible for libeling itself or some member of the staff, or are the students actually responsible?
Oh, or what happens if the student newspaper libels the school board?
Yes.
And then you are literally suing yourself in that situation. Actually, it's a little trickier than that because there are some cases out there, they've never been overruled or questioned, and they draw a very simple line, unusual for the legal profession. The line is quite simple. If you control the paper, you will be sued. If you don't, you will be not. There are 2 cases, one out of New York, Mazart versus State, and one out of Louisiana, Milner versus Turner, both of which simply say where a school district, where a college, where an institution has allowed the independence of editorial speech without any prior review, without any prior restraint, you can't sue them. You can't be held liable. I mean, you can sue them, but you're not going to win. Anyone can sue anyone for anything. You can't sustain the lawsuit. In those situations, you have to go after the students. And a student is not an awfully deep pocket to sustain a libel judgment. The bottom line is the entire amount of all libel cases against high school newspapers ever awarded, totaled up, is precisely 0.
And if Tony will permit me one other question, and it is somewhat related. Earlier you talked about the concept of prior review, which is something that professional journalists absolutely abhor. Don't ever go to a reporter and say, "Now I want to read that first before you publish it." Is that right unlimited to the government, to the school board in this sense? Can they go in and say, "I'm going to read every word of every publication before it goes out"? Or do they have to have some cause before they can come in and say, "I'm going to see that article before you print it"?
Well, again, we have to backtrack to whether or not the newspaper involved is a public forum. And in determining whether a newspaper is a public forum, the issue is how independent is it from the school? If it is an advisor who truly advises rather than edits, if the students do not receive class credit, if they have historically always had freedom of speech, then even if they are on school grounds, they are likely to be a public forum. They are likely to be free from prior review, except when there is a set of pre-existing rules and regulations. The court decisions say there can never be prior review in the absence of a pre-existing framework that lets the students know under what circumstances that review will occur, and those guidelines themselves have to be constitutional. There's a whole list of checkpoints. They almost invariably get struck down because it's a very rigorous test. If, on the other hand, you've got a newspaper that's done and the students receive class credit for it, the advisor is really acting as an editor rather than an advisor, the word doesn't reflect the role, and if it's been a pretty mealy-mouthed newspaper over the years and has no history of editorial independence, then it's not going to be found to be a public forum. If it's not a public forum, all these protections go out the window. The Supreme Court in the Hazelwood case said that if it's not a public forum, the school district can control it for things as simple as grammar, syntax, and the discussion of sensitive issues which the Supreme Court included as meaning the existence of Santa Claus. And I'm quoting the United States Supreme Court on this one. I'm not a real fan of this decision, obviously, but the bottom line is the test now is, are you a public forum or not? So a student newspaper, the editors and the advisor who want an aggressive, useful for its public paper are going to establish themselves in ways that enhance the possibility a court would find them to be a public forum.
A follow-up on that question, Mr. Abrams. Let us suppose that a school district has been in one of these formats and they wish to switch to the other one. They've been very much sponsoring it, and they really are the publisher, versus those who had a much more hands-off. If they're not doing it based on an issue that just arises at that moment, but they just make a deliberate policy decision that they wish to change. Let's go, for example, if it's been very open and free, if they want to go to becoming the publisher, can they do that? Can they change policy based on the precedent they've had?
I think it would be much easier to go from being a public forum to restricting it than vice versa, because the court's going to look at the history of a mealy-mouthed paper, to keep using that term, and say, how come this is suddenly independent? You know, absent a real declaration by a school board, we're never going to touch this again, enshrined in the school regulations, I think it would be hard to show that, particularly if it just coincidentally happens to be while a libel suit's being filed.
That's why my preference was if there's no issue before.
If there's no issue before it, you probably could do that. It would have to be, very clearly defined. Going the other way legally is probably easier. It's probably easier to take a public forum and say, okay, we're going to start awarding credit for this. We'd like the advisor starting in the next school year to exercise a little more control. But you got to consider what the true value of a newspaper is. A newspaper isn't the desks, the typewriter, the room. Newspaper is staff. Like very few other professions, like law, journalism, in skills professions, the value of your law firm isn't the 11 stories of glass high-rise, it's the 400 lawyers. The value of the Lewiston Tribune is not the building. Well, it may be as a saleable business, but its viability as a newspaper is the staff, the brains, the judgment, the experience. That's no less true with a student newspaper. If you try to restrain those students, and they're really feisty, what you're going to get is a mimeograph sheet off campus, and it's going to be truly independent. It may, and what you're doing then, and it would be very unfortunate, is you're forcing your best and brightest students. And in 15 years dealing with this, I have always heard teachers, advisors, and principals say their journalism students are their best and brightest. They're some of the highest achievers, highest test scores, highest academic colleges they go on to. You're taking them, you're taking your best kids, you hope to show that your system is working well, and you're forcing them to choose between editorial freedom and learning. Because they want that editorial freedom, they're losing the advisor. They want that advisor, they're losing the freedom. It's a rotten educational policy.
It's very difficult, very sensitive area. When you were talking about the three areas in which there are some restrictions and use obscenity and libel and so forth, I know that student newspapers are likely not to be in this, but isn't there another category that's more likely to some of the large publications in the country have? And I know it's very difficult to define, but some restrictions on publications that might be seditious or top secret documents and so forth. I know we've had some cases. The Pentagon Papers case went against the censorship, but isn't that another area? Is it, what I'm trying to say, is it possible that somewhere, somehow, a student newspaper could get some information that would fall into that category?
I suppose, and I never underestimate the ability of high school juniors and seniors, that one of them could find the plans for the atom bomb, or a la the Progressive case of many years ago. There has not, to my knowledge, ever been a case of that type. If a student newspaper had in its possession material that was clearly implicating national security, yes, the same kinds of issues would apply as they did under the Pentagon Papers or Progressive cases. I mean, they don't have greater freedom than the New York Times. Our contention is just that prior to Hazelwood, and it should be subsequently, they shouldn't have less freedom either.
One other question I have, and I'll return to the panel. Today, when you were speaking to the high school students, you gave them, I think, some very shrewd advice from experience, and that is, even though they may be under a system where they have lots of freedom and there's the institution itself removed itself from serving as publisher, you gave some advice, though, on what it meant to still be a responsible, effective reporter. Would you share that with our audience?
Absolutely. I think that we overuse the phrase, with freedom comes responsibility. The whole point of freedom is that it is freedom. It's not that you must be responsible. It's that if you're going to defend those freedoms, you should be responsible as a matter of common sense. What that means for a high school journalist is, you're 16 or 17 years old. You're dealing with people in their 30s, 40s, and 50s. You want them to take you seriously. You don't get that by indiscriminate use of four-letter words. You don't get that by April Fool's issues. You don't get that by poor research or poor writing. You get that by holding yourself and your reporters to a very high standard of professionalism, by saying, I'm not a kid putting out a paper for fun, but by saying, I'm a young journalist, and I will behave like a journalist. And that way, then if your principal censors something that's important, like an issue of drug usage in your school, which very few principals want to admit exists, but you may be able to get an angle on it that no professional paper, no parent, no principal, no school board member can, and help the problem that way. You're in a position then to go to the broader community, to your fellow students, to your parents, to the newspaper in your community whose support you may need in a First Amendment fight, and say, this is worth fighting for. This is a liberty. This is not a libertine, you know, and really do the political spade work you need to be taken seriously.
Janelle Berg.
My first question has to do with the underground newspaper that you talked about a little bit earlier. What happens then when the underground newspapers begin to spring up around the campus and people begin advocating all kinds of things, maybe a disruption in terms of class attendance, something like that, if there's a big issue on the school ground?
Well, you can't censor what you can't get a hold of as a matter of technical reality. That actually happened 10 years ago at Brigham Young, which is a private religious institution, didn't have formally a First Amendment issue, but their newspaper, The Universe, had been allowed general editorial freedom, and in 1984, I believe it was, the administration cracked down on it. And one night, the entire staff up, left, had rented space over some coffee shop on 9th Street, and started turning out the 9th Street Rag, or whatever they called it. And the result was they lost their whole newspaper. And once it's out there, you don't own it. It's truly a freedom of these people's extension of their beliefs. And every court has said that on a public institution, meaning a public high school campus, a public college campus, you must allow reasonable distribution. You cannot cut off speech altogether by saying, oh yeah, you can print it, you just can't bring it onto campus. And so if you've got an underground paper, whether it's at Northern Idaho College or at Coeur d'Alene High School or whatever, you are forced to allow it a certain amount of access without distinction. So that's frankly another reason to allow your paper in your school to operate freely. At least you have a basis for dialogue, open lines of communication with your students, and you can encourage more responsible behavior rather than forcing them into a position of open rebellion for the sake of rebellion rather than when it's important to rebel.
My next question has to do with when you have an issue, say for example sexual harassment, that there should be a particular position on, but perhaps the students want to take a different position. What do you advise the advisors to do when they learn that this issue is going to come up, and perhaps it's coming up in a way that might have some jeopardy in terms of how it's going to be expressed?
Well, I think that the job of an advisor is much like the job of any other teacher. It is to inculcate their students in what I would consider basic liberal arts premises. The value of a liberal arts education on the college level is what? To teach people to identify a problem, analyze the ideas, formulate a research plan, conduct that research, collate and assimilate their data, and analyze it and communicate it in some form. That's the basic thought process. It's the same if you're a philosophy major or a math major or a physics major. And for all that you hear out there, that journalism, law, medicine, they aren't liberal arts, I think they're all classic liberal arts. Journalism is ultimately a classic liberal art because you're teaching people how to think. And that's the advisor's job. It's to teach these students how to think. They may still make some mistakes, and they'll have to live with the consequences of those mistakes, because nothing in the First Amendment prohibits subsequent punishment. Suspension for causing the mess or you know, being stripped of their position on a paper, or a bad grade if it's a graded class. The idea is that we preserve the right to make that speech the same way we never correct their math homework before they turn it in, because we're teaching them how to think.
Steve Sheehy. Mark, what was it that attracted you to this area of the law, either as a young law student or a young practicing attorney?
That's sort of fun. I got into journalism very much by accident. My freshman year at college, I just went to the open house at the radio station and discovered that there were a bunch of people as strange and with as odd late night hours as I had, and had always wanted to go to law school. Since I was a teenager, I'd gotten involved in politics, and the lawyers seemed to have all the fun jobs. And bit by bit decided I didn't want to give either up. And so basically managed to combine them, and for many years was doing media law and writing, and I still do a lot of legal writing. I don't practice much media law anymore other than this free student press stuff, because there aren't that many people out there doing it. I do a lot of writing about the law for non-legal publications, the National School Board Journal, the magazine for national school administrators. One of the things I write about is why not to censor your student newspaper. It's a very important area to me, because I do think that, as I said, our student newspaper editors, along with our student government editors, are among the best and brightest students we turn out. We never tell the others not to do what they're doing. Frequently, we do tell this group not to do what they're doing. The consequence, I think, is cynicism and dropping out of the process. And these kids have so much to offer. And yet, if you tell them on one hand in 8th grade and 10th grade civics, this is America, it's a free country, you got freedom of speech, and on the other hand, shut up. You know, what are they going to take from those mixed messages? They're going to take, we're all full of it, and they're going to walk away from us and from the system we've built. And I want them inside fighting to make it better. To me, that's a real important goal.
You've obviously got a background in journalism as well as law, and like most journalists I know, have a love for that profession. How does that play with your fellow school board members in Portland, where you are a member of the school board? Are your views a little contrary to the rest of the group?
Actually, they're not, because I brought with me, and didn't have to show them to anyone today, the Portland School Board Guidelines on Freedom of Expression, which were drafted before I got on the school board, and they are absolutist. They are not allowing for censorship of any form in the Portland School District. I expected to have to tinker with them when I got on the board and was very pleasantly surprised. we've got an interesting board. As I was commenting earlier, we have a new board in Portland, and we're experimenting with a lot of different public policy issues. Fortunately, student freedom of speech is not among them at this time.
Inevitably, students are going to model themselves after the professional media, and that's right and largely good. But journalism isn't a static profession. It changes and it evolves and it goes through trends like most professions do. Is there anything that you see in the professional media that disturbs you, and do you see that being duplicated in high schools and colleges?
Well, I think that the professional media has a lot of disturbing trends we have to deal with. I've never been one to defend my own profession, be it journalism or law. It's impossible to defend law in the general public. Journalism has had a very unhealthy trend towards tabloid reportage, both in print and in the electronic media in the last several years. It's trended that way because people are watching it. And we're faced with that dualism. We are businesses. We're there to make a profit. On the other hand, we have this separately enshrined constitutional obligation. What is the balance between earning a buck and educating and informing our public, even if we earn a few bucks less? We haven't reached a comfortable point in journalism. And the students who see that and see what sells, I think, get misled. And unfortunately, there's a lot of that out there, and there's a lot of stuff that isn't as bad as tabloids, but frankly, USA Today and other newspapers like it, where the content is very thin, where there's, who, what, when, and where, but not an awful lot of how and why.
On that note, we have to bring the program to conclusion. On behalf of our panel and our staff, Mark Abrams, we thank you for being with us today. You have been most informative, and it's obvious that you are an expert in this field, and we know that has been informative to our audience. I would just say to our audience, as we are closing out, that if you joined us late, Mr. Mark Abrams is a noted attorney in Portland, Oregon. He used to work as the director of the Student Press Law Center in Washington, D.C., and we've been discussing the First Amendment and student press law. He's also co-authored a book entitled Law of the Student Press, and we appreciate very much him being with us today. I would like for you to be with us again next week. I hope you will, when we'll discuss yet another subject that we believe is of interest and importance to you and your life. That is the purpose of this program. And we'd like to get suggestions from you from time to time of what you'd like to have on the program as far as subject. I would like to invite you then to be with us again next week. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.